Good morning, everyone. How is everyone doing today? My name is Anthony Ray, and I am with the principal, one of the attorneys here at Ray Law International, for our live stream today. Thank you, guys. Today, we have something really special for you guys. It's a little different format. We're going to have a statement. You're going to say, hey, is it true or false? We'll give you a couple seconds to respond. Put your answer up in that chat over there. And then we're going to talk about that statement and see whether you were right or not. Did you get it right? Was it true or was it false? So we have those all lined up for you today. There's a lot of other things near the end. We have some really awesome topics of recent things that are going on in immigration that you really want to, stick around, listen to, and just make sure that you have all the information you need in order to move forward. There's so many changes in immigration going on right now. We're excited to talk about it. We're excited to answer your questions and to hear from you and to dialogue. So if you're new to the channel, let us know. Go ahead, give us a shout out, put your name, where you're from, what country you're from, and let us know you're there so we can recognize you. And with that, I'm going to turn it over to Lauren for her introduction.
Hi, my name is Lauren. I'm one of the attorneys here at Ray Law. Like Anthony said, if you have any questions or comments, even if they don't relate to our current topics, feel free to drop them in the chat and we'd be happy to answer your questions. We'll also have a number up on the screen or email if you would like to call about a specific question. Since we really shouldn't be discussing very specific questions, we can talk in generalities since we're talking to many people. Saki?
Okay, good morning from Chicago. My name is Saki. I'm a legal assistant at the Chicago office. Today, Chicago's weather is, unfortunately, it's gray, rainy, sad weather. We need more sunshine. Where's the summertime? It's coming, I think. Okay, so before we start everything, let me speak Japanese a little bit. おはようございます。シカゴ事務所の佐田池と申します。今日のライブストリームは、嘘か本当かいろいろ聞く話があるかと思いますが、いろいろな質問に、弁護士が答えていく形式となっております。もう一つですね、弊事務所からお知らせがございまして、今現在ですね、ミシガンオフィス、ノバイオフィスの方で、オフィスアシスタント、日本人のオフィスアシスタントの方で、パートタイムのお仕事を募集しておりますので、もし興味がございましたら、E メールの方で、この画面に出ます E メールの方に、履歴書を送っていただければと思います。よろしくお願いいたします。Alright, so let's start today's topic. Okay, right, so this one's for Anthony. True or false? There is not much difference between a legal permanent resident and a naturalized citizen. Are you muted, Anthony?
So you guys got that question? Go ahead and put that your answers down there. We're going to put this up on the screen for you to give it a few seconds to answer. Go ahead. So I really love this question, you guys. A lot of people just sit in lawful permanent resident status for ages, and they're like, well, I don't want to vote, so I don't need to become a U.S. citizen. All the while, there is a huge push by our government in order to get people naturalized for whatever reason. And a lot of people don't get naturalized or don't become a U.S. citizen for a myriad of reasons. So, is there much difference? I think there's a huge difference, and we're just going to hit on two of them. I mean, there's a long list, but there's two main ones I want to share with you guys today. So the question, my answer to this is there, if a person feels there's not much difference between lawful permanent residence and naturalization, I think that is totally false. Here's my two reasons why. So the first reason is One, if you're a U.S. citizen, in 99.9% of the cases, if something bad goes wrong, you're going to stay in the U.S. You're not going to be deported. Okay. One of the problems we have with our green cards is that if you commit certain crimes or you do something wrong, even if it's indirect, let's say, the secretary or the DMV puts you on the voter's registration, or you made a mistake and you voted, you're not going to get deported if you're a U.S. citizen because you have the legal right to do so. However, if you're an LPR, you can get booted. I mean, it doesn't matter whether you're here 20, 30, 40, 50, 60 years. If you just mess up one time in a major way, unfortunately, you're back on the plane to your home country, or worse yet, stuck in our legal immigration, court system that could take you years to get through. And it's a nightmare, not to mention, the legal costs that it's going to be. So the first thing is, you're not going to be deported if you become a U.S. citizen. I think that's one of the major things. The second thing is, being involved in our, one of the major things, it's kind of like two parts. One is voting and the other is serving out as a juror in a court. So those are certain privileges. While they're not, that compelling, but what do we talk about every day, folks? It's the politics and how that impacts our families. So getting out there and voting, even though some people feel that their vote may not make a difference, it really does. When you look at the elections, it's down to 1,000 different votes here or there in certain areas, especially in a presidential election. So your vote really does count. It can make a difference. And I really would like to stress that. So those are the two main reasons why there's a huge difference between being a citizen and a green card holder or a lawful permanent resident.
All right, thank you, Anthony. Next question is to Lauren. True or false? You will automatically obtain a social security number once you enter the U.S. on a work visa.
Okay, so for this one, this answer is false. You can obtain a social security number once you enter the US on a work visa, but you won't automatically obtain a social security number. If you apply for one, certain applications that we submit have a question. Would you like the Social Security Administration to issue you a social security number? In those cases, it is possible that they will send you one, but lately I haven't seen any of my clients receive one. Usually you have to wait at least a couple weeks, and then you can go to the Social Security office nearest you and apply to obtain one directly. I think they just have too much going on, unfortunately. So if you're waiting and you don't have a social, just definitely make that appointment. You'll have to get one that way. Even if you are applying via one of those applications that says, would you like a social security number, may or may not come. So that answer is definitely false. Saki?
All right, thank you, Lauren. Question to Anthony. True or false? Extending status in the U.S. is the same as obtaining a new visa stamp abroad.
Very, very good question. And anyone have any guesses out there? Go ahead, place it in the comment. Is it true or is it false? Let us know in the comment section. Also, remember, if you have other immigration questions, go ahead, write them in the comments. Let us know that you're out there, or if you have questions. So extending status in the US, is it the same as obtaining a new visa stamp abroad? And again, this is going to be false. Okay, these are two completely separate processes. They do two different things, two things which are completely different. The way I usually break it down for people is, for extending a status, that's usually extending your status here in the US, and what's represented of that status is an I-94, your arrival or departure card. Nowadays, most of those are going to be electronic. So you can look those up on the not the USCIS, the CBP website. And then on the other hand, we're talking about getting a new visa stamp abroad. So those are two separate things. The visa stamp is going to allow you to get a stamp in your passport that allows you to enter the United States. And then once you enter the US, then you're granted a particular status. So those two are not the same. They work together in many cases. Sometimes just getting an extension allows you to stay here. You don't have to worry about getting a new visa stamp. Now, in the old days, we could apply for a visa stamp here in the US way back when. It's probably a lot of people may not know that or may not have heard of that, but you could. You can file here, get that new visa stamp through the Department of State in the US, but that's all changed now. Anyone who wants to get a visa stamp must get it while they're outside the US, okay, at a US embassy or consulate. So again, false for this one. And if you have questions, let us know. We can help you out on either way, on either of these processes.
Thank you, Anthony. Question to Lauren, true or false? Employment-based green card applications will not have an interview with the USCIS.
So this one is going to be mostly true. Most employment-based green card applicants at this moment are not getting interview notices. So they submit their application, they do biometrics, then they wait probably a long time because the processing times for USCIS are pretty bad right now. And then eventually they just get an approval notice and their green card in the mail. Now that is not every single employment-based applicant. It seems to depend on where you live. Some field offices have decided to reinstate interviewing people. Prior to the pandemic, all employment-based applicants were getting interviewed, so they seem to be going back to that. Other ones, maybe they have a question about your specific application, or they have a question about the company, and they decide, hey, we need to talk to this applicant in person before we can approve it. Now, it's not the end of the world if you get an interview. We've had a number of clients get interviewed and then immediately after get their green cards. So not the end of the world. Definitely have an attorney prep you. But in some, I would say this is probably 90 to 95% true, and then maybe 5 to 10% false because some people are getting interviewed. Saki?
All right, thank you, Lauren. Question to Anthony, true or false? TN and E2 visa holders cannot apply for green card.
This is a very good question as well. We get this quite often for people holding the TN or E2 or E1, just the same boat. So what do you guys think out there? Is this true or false? I mean, I think you'll hear a lot. It really depends on who says it and how they give it to you, because all too often, as I'll talk about a little later, all too often on the internet or through Google, no one gives you the full details. And of course, that's why you hire an attorney to get all the details and understand the case thoroughly. But what do you guys think? True or false? Let me know in the comments. Okay. My position on this is it is false. Okay. Here's why. All right. So most people will look at the TN, the E1, E2, and say, these visas do not have what we call dual intent. What is dual intent? First of all, we have to understand what intents are we talking about. There's two types of intents that we have in immigration. First, we have an immigrant intent. Second, we have a non-immigrant intent. An immigrant intent is basically, I'm going to come to the US and stay here permanently. The non-immigrant intent is basically saying, I'm going to come here temporarily, then I'm going to go back to my home country. An example of a non-immigrant intent visa is the F1, TN, and E2, E1. And then our immigrant intent, or one that has both dual intent, meaning immigrant and non-immigrant, can be our H-1Bs and Ls. Okay, so now that we understand what types of intent we have, now we can get into why we're even having this conversation. So in order to file a green card, meaning that's an immigrant visa or an immigrant intent, you cannot be in a category that is not dual intent. Under the immigration regulations, the regulations specifically state, hey, these visas, you can have dual intent, such as our H-1Bs and Ls, it's okay. It's sort of a legal fiction. Basically, hey, if you're in this H-1B category, you can say, yes, I'm going to be here temporarily, but no, I'm going to stay here permanently. Okay, that's the dual intent. So how do we get around this, right? So one of the main things to, what we approach it is, it's all about timing. During the green card process, at a certain point, you cannot travel back and forth, or it will be a conflict between our, FRTNs and e-visas. So with our TN visas, what we do is we talk to our clients, we plan in advance, and then basically once we filed our green card. Now, remember, in the green card process, depending on which one you're doing, that's a 3-step process. So we're just talking about filing the I-485 or even the immigrant petition, I-140. So once you're at that stage, then we're going to ask those clients to stay put. Don't go back and forth, because CBP or other immigration is going to challenge your true intent. So basically, is this false? Yes, because there's always a way to deal with it. And we've worked with numerous TN holders, e-visa holders. They are happy green card holders today, and we work through that process with them. And this is all because of this archaic immigration system we have. This part would be false. There's a way to do it. We can definitely help you. If you have questions, put it in the chat. If you've experienced something different, put it in the chat or the comments and let us know. Thank you.
All right, thank you, Anthony. Next one, a question to Lauren. True or false? It is legal to own and operate a business in the U.S. without the work visa.
He's getting better and better at saying the word false. It's hard for Japanese. For this one, this is also going to be a partial true, partial false. You can definitely own and operate a business as long as it's a passive income. So let's say you own some real estate and someone else is hired to manage the business. They're taking care of the properties, they're doing the accounting and stuff like that, but you are the owner, so you are making a passive income. You are allowed to do that. You don't need some sort of specific visa. However, if you are taking any active role in that business, you need some sort of work visa, some sort of status, work permit in order to do that. So if you are looking to open a business, we do a lot of consultations on that. We can definitely help you out to set it up, either so that it's a passive income, or we can let you know which work visas, or if it's possible to apply for a work permit, what would be the best strategy for you. So another one that's partially true, partially false. It's going to depend on your situation. Saki?
All right, thank you, Lauren. So next question is to Anthony. True or false? It is illegal to enter the U.S. using Esta to provide training to U.S. employees.
Anthony, you're on mute.
All right. Here again is a very good question that we get often. What do you guys think out there in the audience? True or false? Go ahead, put it in the comments. Let us know. Give you a couple seconds. All right. So in this case, is it legal to enter the U.S. using Esta to provide training to U.S. employees? The answer for this one's going to be true. Okay. Now, even though legally it's true, you don't want to just show up at the border and just wing it. You want to be prepared. So another thing before we start, I know we use the term Esta. Remember, Esta is the actual system where you register under the visa waiver program. The proper terminology is the visa waiver program. And when it gets stamped, you'll see, of course, the VWP in your passport. You won't see Esta written on your passport anywhere. Remember, Esta is just that system you register in to get approval in order to use the visa waiver program. But under the visa waiver program, or if you happen to have a B1 visa, which is business visitors, training employees or coming to the United States to train employees is perfectly okay. Now, on the surface, that looks really good, but our government's going to look a lot deeper than that, okay? You're going to want to make sure that you have an invitation letter detailing what kind of training is going to happen, how long it's going to last, how long do you need to be in the United States, who are you training, okay? Is it a client? Is it for within the company itself? Is it for compensation or not, okay? Also, very important, is the person coming over, are they qualified? Did they just come out of college with no training and they're supposed, with no experience and they're supposed to do training? Officers will look into that. And if a person isn't even qualified to do the training from the interview that they have at the border or doesn't have proof, the officer or CBP officer is going to question that. So make sure you have evidence, one, of the actual event, have an itinerary, an invitation letter that is completely detailed with contact information in the US so they can be verified. And then finally, make sure you have the qualifications of the person coming over, whether that's a letter from the home company or main company that they're coming from abroad. Maybe it's degree certificates, maybe it's some experience letters, or maybe some type of certification depending on what that training is. So for this one, we'll give it a true.
All right. Thank you, Anthony. Question to Lauren. True or false? Legal permanent residents need to provide USCIS with an updated address at all times?
So the answer to that is definitely true. If you are a legal permanent resident, you do need to update USCIS with your address. A lot of people don't know that. It's really, really easy. So no worries if you haven't been, just definitely make a point to do that right now. Hi, parties. So for to update your address, all you have to do is go online and Google the words AR-11. It'll take you to a simple form. It'll let you put your name, your previous address, and your new address, and USCIS will send you a confirmation they received that. It's really important to do that so they can be in contact with you if there is some sort of issue, and so the government has some idea of where you're living. So the answer of that is actually true. Saki?
Thank you, Lauren. Question to Anthony. True or false? Non-immigrants are required to carry an approval notice with them at all times?
All right. What do you guys think out there? Do non-immigrants, people who hold visas, do they need to go around and carry that approval notice in their pocket all the time? Give you guys a few seconds to figure that out. Write it in the chat. Let us know, true or false. Now, this one, I'm going to pull one from Lauren's, partially yes, partially no. Generally, there's no requirement. So let's just say it's false, okay? And the reason for that is no, you don't need to put that in your pocket and carry it around with you, okay? However, the law does require us to provide evidence of our status. Now, do you need to have that when you get pulled over from a traffic stop? Do you need that when you're at work and the Department of Labor comes to do an on-site visit? Or in any other circumstances. So normally you don't. Here in the US, most of the time, as long as you have, for example, have a valid driver's license, the police isn't really going to inquire into your status, or they shouldn't unless they have some reason, probable cause to do so otherwise. And at work, normally the Department of Labor doesn't come and visit your work site unless your employer is doing something really bad. And in that case, there's probably greater problems than you carrying this notice. Now, there are times when, for example, green card holders are supposed to carry evidence of their status. So, most of the times you'll be allowed to go back to your home, retrieve that document, or if you have it in the cloud, retrieve that document and show it to the authority figure. So there is technically, you don't have to have that approval notice, that I-797 tucked in your pocket. It wouldn't hurt to have it on your digital device, maybe your phone, iPad, or whatever device you use, have it on there so you can show whatever authority, whether it's immigration, the police, or someone else, that you do in fact are authorized to reside in the U.S. or in some cases actually work in the U.S. So false for this, you don't have to carry it around, but you are supposed to be able to show status. Most countries have that requirement that you're supposed to always provide evidence of your eligibility to be in that country. The US does too, but you don't have to carry that particular notice. Put it on your phone, have a digital copy, you'll be taken care of.
Thank you, Anthony. It's good to hear that you can carry the digital one because, if you put the paper in the pocket, you may forget and then put in the laundry machine and then you will cry next day. So, so that's good to know. Next question is to Lauren. True or false? Non-immigrants cannot extend their driver's license while an extension is pending?
Thanks, Saki. So by this question, it means that let's say you have your status and it expires tomorrow, May 19th. But you filed your extension, it just hasn't been approved yet. What do you do after May 19th? Can you just not drive? Well, some DMVs are going to give you a hard time, or Department of Motor Vehicles, whatever it's called in your state. However, they definitely can extend your driver's license based off of your receipt notice. So you can bring your receipt notice, let them know that you have extended, but you're waiting for that approval notice. Sometimes the lower level employees don't know about this rule, so you may have to ask to speak to a supervisor or someone higher up that may know this rule. Sometimes our clients have to visit an entirely different DMV. The first DMV, they'll get denied, and then the second one, they'll get a license extension. Usually this will be based on 1 year increments. So they won't give you that whole 3 years that maybe you had before and while your visa was valid. But they will give you a year, and then once you get the approval notice, you can extend again. So definitely ask to speak to a supervisor and let them know I am eligible to extend my driver's license. So this is false because you can extend your driver's license while your extension is pending. Saki.
All right. Thank you, Lauren. Let's take a break from this true and false game and then go to the coffee break question. So today's question is, what is your favorite summertime hobby? Start with Anthony.
Absolutely. So I am going to share a picture also. Hold on, let's do this. So what I enjoy doing in the summertime is gardening. And this is just a quick picture of some of the plants that I'm growing that's going in my garden. I usually grow mainly vegetables instead of, and a few flowers as well. So in where we live, our summertime, our growing season for warm weather crops is just 3 months. Very short. So this 3 months is very precious for us, mainly, June, July, and August. So we often get our seedlings and everything growing well in advance. So the next 3 months, we're in heaven. So I enjoy gardening, grow this year probably about 8 to 10 varieties of tomatoes, several types of cucumbers, okra, pole beans, and a few other things. Now on the flower side, I'm not as adventurous. I grow marigolds and zinnias. Marigolds mainly to repel pests, and also they're a flower I just can't kill. I mean, they are so tough. They last into the fall, so they're beautiful, and they last even when I'm not, when I neglect them. The zinnias are great for the pollinators when they're coming to the garden, really to attract them, so that everything, nature does its thing. This year we're excited. We're hoping for a lot of sunshine, a lot of warm weather, 70s or 80s for those in the States, and then also just the right amount of rain. So that's what I do during the summertime as a hobby.
Awesome. How about you, Lauren?
So for me, I like gardening too, but I live in a condo, so I just have a small balcony. Nothing crazy like Anthony. So I'd have to say that I like to play volleyball. I'm not that good, but I'm okay, and it's really fun. So in Chicago, obviously we have Lake Michigan. We have really nice beaches. So me and some friends play beach volleyball pretty much once a week all summer. And last year, somehow we ended up winning our league, even though I swear we are not that good. So that's a really fun time. What about you, Saki?
My apartment, I don't have a balcony, I don't have a garden, so I can't do gardening. And then plus my apartment is like super hot. Lauren's always complained I should get the AC as soon as possible. So my hobby in the summer is just definitely going outside, enjoying the weather. I don't have a gardening, but I'm same as a plant. I need a sunshine. So so I usually go outside by the lake, read the books, hang out with friends, do barbecue, any summer outside activities, and just not think about the winter. That's all I enjoy. All right. Okay, let's move back to the true and false game. The question is for Anthony. Anthony, true or false? There is nothing you can do if your case has been stalled at USCIS for a long period of time. You just have to wait or apply premium processing.
Yeah, a lot of people really feel this way, right? That there's nothing you can do. How do you get the government to do what they're supposed to? So what do you guys think out there? Is this true or false? You can't do anything. You just got to wait it out. What do you do? Wait for your answers, true or false? Okay, in this case, it's going to be false. However, it's going to be a false with quotes on it, quotation marks, because, to actually get the government to do what they want to do, it's going to be a lot of work or it's going to cost a lot of money. Okay, sometimes both. So it all depends on the type case that you have, depending on how you get the government to move your case forward. Also, we mentioned premium processing. So for example, in certain cases, you can give the government an additional filing fee to move and process your case quickly within 15 calendar days. That's what premium processing is going to do for you. Now, not all cases, both on the non-immigrant and the immigrant side, qualify, so it's not going to help every one of you guys out there. It's really going to depend on the type case. If you're filing, for example, generally speaking, a non-immigrant visa where you're filing the form I-129, such as H-1Bs, Ls, Es, R visas, Os, and others, you're going to be able to file premium processing, but it's going to come at a cost. For most of the people out there, it's going to be $2,500. So that's a large amount just to dish out for the government to do their job in 15 days. Alternatively, for other categories such as H-2Bs or others, it's reduced quite a bit, but it's still, it's still a lot of money that you don't want to spend in order to get the government to move quickly. Now, if you are in a category where premium processing is not available, such as a lot of green cards I-485 adjustment of status cases, or for example, right now we should have premium processing, but right now EEDs are not premium processing. The government is working towards that, so we're going to look forward to that. Not that anyone wants to pay more money to get the government to move quickly, but this is the way that we're heading. But for example, EEDs or adjustment of statuses, what you can do, there's a lot of things you can do. One, contact your congressman, get an attorney to help go through the process, call the USCIS customer service and sit on the phone for 2 or 3 hours. You can, reach out to the ombudsman. We have several videos on our YouTube channel that talk about the various things that you can do and the actions you can take. Another one is the mandamus. It's filing a mandamus action in federal court. Not everyone is up to suing the federal government. A lot of you guys out there want to sue the federal government. This is your opportunity. The problem is that, the reward is just to get the government to do what they should have been doing after a long period of time. I mean, you don't get your attorney's fee paid for. There's no, compensation you get for your lost time. So it's a costly event, but when you think about a mandamus action, as long as you get your green card, then you can move on with your life, whether that's starting a new business, starting a family, or traveling to see family abroad. That green card is going to allow you to do what you need to. Or if it's a work permit, you're going to be able to support your family, pay the bills. It may be important to file certain actions, but by all means, there's several things that you can do. The answer for this one's going to be false. It's just the, actions you're going to need is going to be very costly, or it's going to take a lot of time, or maybe both.
Thank you, Anthony. Question to Lauren. True or false? TN visa holders must be paid from the U.S. petitioning entity.
So this is an interesting question, and it's actually something that a lot of either USCIS or CBP officers may get wrong, but the answer is actually false. There's nothing in the regulations that states that the U.S. entity has to pay a TN visa holder. So what does that mean? It means if there is a company that has an office in Mexico and an office in the U.S., maybe for tax purposes, or maybe it's easier for payroll for whatever reason, that Mexican entity can continue to pay the salary. Now, it has to be the salary that was submitted in the application for the TN visa. It has to be that same amount. You can't underpay or something like that. But this is going to be false. TN visa holders may also be paid from the foreign entity. It does not have to be the U.S. petitioning entity. Saki?
All right, thank you, Lauren. Question to Anthony. True or false? Adult children can be in the U.S. on the dependent visa status until age 24?
Very good question. What do you guys think out there? True or false? Is 24 the magic age out there? Let us know. Give you a couple seconds to place that in the chat. All right. So the answer to this is going to be false. Okay. Now, the magic age really is going to be 21. Some people get it confused with 18 sometimes, because in the US, turning 18, you become an adult. Why 21? For whatever reason, at that time, the USCIS or the regulations of the government chose 21 for that trigger date. So they can be an adult for other reasons or other purposes, such as they're over 18, and they can still be a dependent on a visa, whether that's a non-immigrant visa or an immigrant visa. Now, be careful. Often you'll hear things such as maybe your medical insurance, for example, may allow you to keep your children on as a dependent. up into the age of 24 or beyond the age of 21, don't let that confuse you, because, touch base with an immigration attorney. We're going to let you know if there's going to be a change. We'll update you and let you know, but it's going to be 21 for pretty much everything. Now, there are some exceptions. For example, if you're going for a green card and your immigrant petition is pending for a very long time, you might be able to recapture some time and still get that child a green card under the Child Protection Status Act. That's a whole nother story, maybe a whole video series that we can talk about and get into details, but there may be certain exceptions. But the number you're going to want to remember is 21. Stick to that. And if your children are 2 or 3 years towards that, if they're, 18, 17, you want to get in touch with an immigration attorney to see what their options are going to be. Do they need to switch to F1 or another visa category so that they can remain in the US? Or are they going to lose out totally for a green card and have to find another way in order to get their green card if they're abroad or if they're in the United States? So a lot to consider here. Magic age is 21. That's what you need to remember.
All right. Thank you, Anthony. Wow, 21 is just, it's going to be really fast. So if you're in a high school right now, you may start to think about, the future. Being an adult is a little tough, and even the immigration. So if you're in the high school, study hard, work hard, do your best. All right. Next question is to Lauren. True or false? L1 status will be invalid if the parent company gets purchased by a new entity.
Thank you, Saki. Love the commentary in between. Since I'm a little more boring, Saki can entertain everybody who's watching in the meantime. So true or false, L1 status will be invalid if the parent company gets purchased by a new entity. Again, that is going to be partially true or partially false. Really important to speak with an immigration attorney on that one. The reason being is you need to be sure that the purchase, that new company is going to acquire all of the assets and liabilities of the parent company. If there is some sort of partial sale that could create some sort of issue with your status potentially in the US. Let's say there's just some sort of reorganization, but it's still owned by the general corporate same structure. Well, in that case, no, there's no issue. But always best, definitely check with an immigration attorney, make sure that it's not going to impact your status in any way. Better safe than sorry. You don't want to go to an interview at the consulate and get some sort of denial that is forever on your record because you thought there was going to be no problem. So true and false. I don't know why it's set up so I'm getting all these kind of true, kind of false ones. But as with a lot of immigration, there's gray areas. So definitely contact an attorney. Saki?
All right. Thank you, Lauren. Next question is for Anthony. True or false? E2 status will become immediately invalid if the U.S. entity is sold to a U.S. citizen.
All right, very good question. I was just looking at the time. We are getting towards the end of our hour, so I'm going to try to give a quick answer so we can talk about all the other stuff we wanted to talk about. But what do you guys think, true or false? If sold to a U.S. citizen, will the status go away? Now, the answer to this is normally, and 99% true. Why is that true? Basically because for E-status holders, the companies need to be held a majority or control by the foreign national or the foreign national company. And if that changes, well, you don't qualify for the E visa anymore, E1 or E2. So before you sell your business, before there's a business transaction, please, please, please get in touch with an immigration attorney to see how that's going to impact any of your foreign nationals working in the United States or who are planning to come to the United States. All too often, we just focus on the deal, but really don't take into account the impact of that deal. So for this one, is it going to be immediately, legally, theoretically? Yes. Is the USCIS going to show up at your door the minute that document is signed? Probably not. However, it's on the foreign national to protect his or her status, and you can argue when that happened or didn't happen. It's going to be the CBP officer, the consular officer, who's going to make that call, and it's probably not going to be in your favor, okay, unless you have a lot of documentation. So immediately, I'm going to go with true on this one. Definitely, as Lauren just mentioned, you have to have an immigration attorney involved. These are very complex issues with a lot of variations. You don't want to be doing it by yourself. All right, Saki, give us the next one.
All right, the next one is to Lauren. True or false? H&E dependents don't need EAD to work in the U.S.
So this one is going to be false because H dependents definitely need a separate EAD, employment authorization document, in order to work. They are not authorized to work just because they are in H4 status. Similarly, there is news out now that the E2 dependents certain E2 dependents do not need EADs. Now, this is complicated because if you're just saying all E2 dependents, that is going to be false, because you could have a child that is an E2 dependent. Even an adult child, someone who's 18, is still, as we said earlier, going to be counted as an E2. However, only E2 spouses are authorized to work incidental to their status. So USCIS and CBP have been updating the I-94s to say that a spouse is going to be designated as E2S, and then children obviously will not have that status. So as long as you have that E2S, dependents are authorized to work without an EAD. If you are an E2 spouse, but you haven't received an updated notice from USCIS or CBP, definitely contact your attorney so that we can contact USCIS or CBP on your behalf to try to get that fixed. Although technically you would be authorized to work even if you don't have that, the problem is that your employer is going to have to verify your status for their Form I-9. That's an internal employer form. And if you don't have that E2S status, even though you are an E2 spouse, the employer technically can't fill out that Form I-9 for you. So you wouldn't be able to work anyway based on that. So definitely need to get that fixed up. Make sure it says E2S, and then you'll be good to go. For H4, cannot work without an EAD. Saki?
All right, thank you, Lauren. So yeah, we do hear so many different type of news, and then like now we're like, is this true or false? Like, is it really true? Because like especially like today, so many things are changing, and then the COVID. So Anthony, do you know anything the true news about the COVID for the information?
Well, absolutely. One of the things, and we really don't have a lot of time to unpack this. I'll follow up on this on the weekly chats that we have in the evenings throughout the week. But Title 42, it's huge, right? Biden has said he's rolling back some of the COVID restrictions, but a lot of people are up in arms, like, oh no, all these people are going to come in. Now, granted, the problem is that our immigration problems cannot be solved in 2-year cycles based off of political, ups and downs. We have an immigration problem here in the U.S. And so when Title 42 was put in place, Section 256, it was supposed to keep people out because of some disease or some problem. but it made no sense because we're still letting people, cross the border and stuff. It was really, people still came to work. So the reason the rule or Title 42 was used is really just to keep immigrants out. That was it. It wasn't to keep out a disease because people are still going back and forth between Mexico and other countries. So now Biden is rolling that back and he's getting a lot of backlash because a lot of people just look at, what's going to happen. Now, because of Title 42, 1.2, 1.7 million, whatever article you look at is, keeping people out. But realize people have a right to apply for asylum. Okay. So, it's Title 42 is really unique. There's even discussion to say that it can keep U.S. citizens out. It can keep me out of the U.S. if if the government makes certain things up. So it's a dangerous tool that hasn't been used until recently in 2020. It hadn't been used since 1944, I believe. And unfortunately, I think, at this time, the administration is doing the right thing because it was improperly used. The problem is that we here in the U.S. have an immigration problem, and it's not going to be solved by Title 42. It's not going to be solved by restricting or these small things. We need real immigration reform. We need a problem to our solution. Tens of millions of people are here illegally already. People are legitimately applying for asylum. And I think as we watch this unfold, the date, just remember, is May 23rd, just right around the corner. So you're going to be hearing a lot about this. It's not simply that a lot of people are now going to come in. They're still coming in, all right? Title 42 is not the tool to keep people out. It's not a tool to fix our immigration process. So I'm going to let Lauren go to the next one because I have one more I want to get to as well. Go ahead, Lauren. What do you have?
Are you muted?
Oh, sorry. Thank you, Saki. So for this next one, we were going to bring up for Indian nationals, EB2 is moving very quickly. We are very happy to see this. They have stated that they're going to move quickly, but even recently for next month in June, they move forward for EB2 almost a full year. So a lot more people are able to file for their green cards. Or if you were one of those people who filed in 2020 using a downgrade to EB3, you're able to interfile and go to EB2 category using their interfiling mechanism. So it seems that for people who are doing interfile, they are getting the green cards pretty quickly. USCIS has a lot of stated goals, but they don't always execute on them. They made this goal, and it seems like they actually are executing, and people are getting their green cards quicker from interfiling. So definitely something to keep in mind. Keep watching the Visa Bulletin. Hopefully we're going to see a lot more people get their green cards prior to October. Anthony?
That would be awesome. I mean, if we can file more green cards and get people through the system, there's hundreds and thousands of people out there who are really stuck because of the visa backlog. If we can move those people along, that'll open it up for other people, and they're not going to have to wait 5, 6, 7, or 8 years to get their green card. So the next topic that we have wanted to bring to your attention is the Biden administration is making it easier. Not really an easier, but making a priority for those individuals in the STEM field. If you don't know what STEM stands for, it is the science, engineering, technology, and math fields. If you're in one of those fields, you want to apply for a green card. Now, you can do that under the National Interest Waiver, which is under the EB2. Feel free to talk to us. We have videos out there, but reach out to us so we can evaluate to see if you qualify. Also, I want to mention, as we talk about STEM fields, if you have a PhD and you want to see if you qualify, maybe under the EB1, EB1A, extraordinary ability in the arts, sciences, athletics, or education. It doesn't have to be something fancy. You don't have to be an NBA, player or a baseball player, you may be an expert or an extraordinary person in one of those areas. So if you got a PhD, reach out to us, talk to us to see if we can get you and your family your green card to move forward. Now, the Biden administration earlier this year really stressed the importance of getting STEM workers to stay here, getting people here. Why is that? I just talked about this yesterday. They're hiring everywhere. Everyone is looking for expertise. We're adding 400,000 plus new jobs every month in the U.S. We need people to come to the U.S. and work. We also need the government to open up easier mechanisms for people to come to the U.S. and work. Right now, there's limitations depending on whether you're a professional, a person of extraordinary ability, or whether you're a skilled worker or in agriculture. So it's so challenging. We need to streamline the process and make it a lot easier, like for other countries. It'd be great if we just had a work holiday visa. People just come over and work for 6 to 12 months and go back to their country. Make it easy for foreign nationals. Make it easy for us employers to get the support and help we need to move the economy and get it going forward. And as we see so much happening in our world today, this is going to even be more important, because if we've got to produce more here because the world is crazy out there, we need people to do that production. Okay. So that's my topic. PhD holders, reach out to us, EB1 or A, EB1B, also outstanding professors and researchers. And then also, if you're in the STEM field for national interest waiver, give us a call so we can evaluate and see what we can do for you. All right, Lauren, I think we got one more.
All right, well, we don't have much time left, so just really quickly, Ukrainian nationals, I was going to mention, are eligible to file for temporary protected status. I'm sure, unless you're living under a rock, you've heard of what's going on in Ukraine. So Ukrainian nationals, whether or not they had status at the time, if they've been living here since April, I think it's April 11th, you would be eligible to apply for protected status, which means that you can get an EAD and also that you can't be deported, because that would be pretty unethical for the U.S. to deport you to an active war zone. So just FYI, if you are Ukrainian or there's someone Ukrainian that you know, that maybe they were here on a tourist visa or they were here without some sort of status, make sure to apply for that, get the work permit, at least some quasi status to stay here and make a semi-permanent life until Ukraine is more safe for people to go back. Anthony?
All right. So we want to thank you guys for joining us today. Feel free, if you have questions that were generated from our discussion today, feel free to reach out to us. Vladimir is there to take your calls and get you scheduled for a consultation with us to see how, what we can do to take your case forward. Remember to visit our YouTube channel, as our goal this month is to hit 5,000 subscribers. We're close, but we're not there yet. So we need your help to reach that goal. Go to our YouTube channel, hit like, subscribe, and also hit that bell for future notifications as we put more information out there to help you reach your immigration dreams and goals. With that, thank you guys. We'll be here next month with a new topic and with something new to, introduce what's going on in immigration. So stay tuned and we'll talk to you guys later. Thank you guys.
Bye.